Hi everybody, I'm Arkady Frekhtman and I'm here with
Richard Mogg, trial counsel for the firm.
And today we want to talk about this case where last Monday we got a $2.2 million settlement in a little bit of a different type of case. And we talked to you last time about liability, who was at fault and why. And now today we want to talk about damages. So any case, the jury has to answer questions. The first question is, was the defendant negligent? That has to do with liability, right? If you're negligent, you fail to use reasonable care. Then they ask, was the defendant's negligence a substantial factor in causing the accident? That's known as causation. You have to prove that whatever they did, the mistake caused the injury. And then if they say yes to that, the third question is, state an amount that justly and fairly compensates the plaintiff. So that's right from what the jurors see, right? That's right from the verdict sheet. So let's go over it. Today we're going to talk about damages, all of the harms and losses. This is a life-changing forever injury, but why? And also talk about the medical diagnosis, the way we prepared the case with experts, talk about the plaintiff's life and how his life was changed and how we did a deep dive. We went to his house, we got to know his friends, his family, and we got a few stories of how his life was changed and how the entire family was impacted. So let's get into it.
One of the things that we routinely do when we first pick up a case such as this case is we try to dig into the background of our client, actually asking questions about his loved ones, the things that he loves to do, hobbies, all the things that were going on before the accident happened and kind of took those precious things away. And in developing that, of course, you go through his medical history. In this case, our client was asymptomatic. It's a fancy term, which means up to when the accident happened, he had no problems with his neck or his low back. It was only after this accident occurred that we had medical proof that this accident caused the injuries to the neck and the back. Now, Arkady spoke about a very important point. During a trial, the judge instructs the jury that the plaintiffs, we have to prove for our client that the accident caused the injury. That has to be to a reasonable degree of medical certainty. It's a terminology, a phrase, a term of art, which we have to meet. If we can't prove that, under the law, the case can get dismissed. So the second point that Arkady brought up about witnesses, expert witnesses, is a very important part of the damage aspect. We spent many hours pouring through the medicals, pouring through the operative report for our clients' low back injuries, and then meeting with the experts. Matter of fact, it was about a half a month ago, before this case actually settled, that Mr. Frekhtman and I went out to the surgeon and spoke to him.
Yeah, to the surgeon and also to the client's house, and we did a lot of investigative work. I also spoke to a few witnesses, the client's friends and his brother and his family members. So what happened right after the crash? So the crash happens, the car flies up into the air, it lands back down, and then what was the injury? What was the medical treatment that was had right away at the scene?
Okay, so first thing, and it's very important, is the accident. How does the accident relate to the injuries that our client sustained to his neck and his low back? Well, a doctor conducts an examination of our client, but the first thing we look at is what was said if and when he went to a hospital. So we check the hospital record. Look in the hospital record, there it is in black and white. He got there at 3 o'clock in the morning after the accident happened because the defendants were arguing, hey, he couldn't have been seriously injured. He didn't go to a doctor or a hospital right away. Just use your common sense, viewers. Who goes to a doctor or a hospital at 3 o'clock in the morning unless you are in some type of pain? And take it on top of it was COVID. So he really didn't want to go to a hospital, but because the pain was so bad, he's there at 3 o'clock in the morning in a hospital. And Arkady discovered, looking at the records, I remember him calling me up and, did you see it, Rick? He complained right in the record, I've got back pain and neck pain, and I went over a loose manhole cover. The whole case was right there in the history. So right away, we start making the connection. Then we have to look at the doctor's records to make sure that his treatment and the findings of the doctors by diagnosis show the low back and the neck are causally related to the impacts that occurred in this accident.
I did a 3D timeline of all his medical treatment. It started with the actual manhole cover injury. Then it had the emergency room. I believe he went to the emergency room the next day, right?
Actually,
or at night, like you said,
3 o'clock
a.m.
in the morning.
Right, 3 in the morning. So it was like pretty much the same day. And then the next one after that was the physical therapy. It was just a few days later. And he continues the physical therapy all the way until May 8th of 2019. So that's, that's a considerable, that's 5 plus 5, that's 10 months of physical therapy. So that's a lot. And during the physical therapy, he's also doing other things, like he's seeing specialists, he's getting, different types of care. So it's not just physical therapy.
And up to that point, again, we're developing what we call the human story. So we learned from our client that before this accident happened, he was an avid handball player, basketball player. He worked out in the gym with his twin brother, did all types of presses and push-ups, very active individual. Accident happens, that's all done. Plus, he had a very interesting employment history, which wound up having him being a producer for TV shows and movies. He also was a tax preparer. The production business, as he told us, was a very physical business that he was involved in. He would bring lights and cameras and all types of props to stages and places all over New York City. He worked with 50 Cent, he worked with Al Pacino and various other stars. This all ended. It's all part of our story for us to bring to the jury as to what he lost as a result of the injuries he sustained in this accident going forward for the rest of his life.
There were some issues with the case. Like, one of the issues we found on our own was that while he was getting a lot of treatment, there came a point where he reached what's known as maximum medical improvement, and then he stopped treatment. So I think that was around May of 2019. He stopped treatment, and then there was like what you call, some people would say, a gap, right, where there's no treatment. And that was right around the time that COVID happened as well, because you're getting into 2020. And then in 2021, he goes and he can't deal with the pain. So he tried to go back to normal. He tried to live a pain-free life, but he couldn't. And then he goes back, and at that point, the only option is a full-blown surgery, which he had in March of 2021 when he goes back to Dr. McCagno, and he tells him you need a surgery. The other thing that they were harping on was, I guess, this issue where they followed him around and they did surveillance and they exchanged a video with us. And Rick could talk a little bit about that, or we could get into that, because that's something also that we have to deal with in cases. And if you have a case, you have to be careful of that as well, because they could hire somebody to sit outside your house, usually maybe a retired police officer. He'll have some donuts and a newspaper, and when you come out, he'll start videotaping you. And what he wants to do is he wants to catch you doing things that you testified in your deposition you cannot do. And so if they do catch you doing that, then that's very powerful evidence, right? Because you're bringing a case, you're there trying to get millions and millions of dollars for a life-changing forever injury, and you're this victim. But they're trying to say that you're not, that you're a fraudster, you're a liar, a cheater, and a fraud, and you just want to win the lawsuit lottery. And Rick will talk more about that.
So what happens is he's sitting at the desk. Suddenly, my paralegal walks in and says, "Here, Mr. Mogg," and flops a CD down on the desk. I look, it says the name of the client. I know right away, especially because we were only, 10 days before trial, I received a CD, and it's a video of my client over a time frame. In this case, it was like a month before, up to about when I got the video, maybe 2 days, 3 days right up to that. The video showed my client walking around with his cane, because he was prescribed to use a cane and was using a cane. The video basically only showed him walking somewhere with the cane, walking out of a car, walking in and out of a drugstore. Really didn't show much. But the problem is as trial attorneys, we look deeper into the videographer, the ulterior motives behind that video. So we have a notice. It's all written up, and we make demands right away of the defendants. We want to know the position of the videographer. We want to know where he was when he took the videos. Did he have any notes explaining to him what to look for? Do we have any audio? So when you saw him walk in and he pushed open the lobby door, we can hear him groan from pain because he couldn't open it. And we go through a list, and then we ask the court, give us a deposition of this videographer. So then we can sit that videographer down and ask the videographer questions to show this is a setup. You're sitting there behind blacked out windows, and like Mr. Frekhtman said, you're having a donut, and maybe you get 1 hour out of 24 hours sitting there. Are there any cuts in the video? Why did you stop it? Is it because 2 seconds after he tried to open the door, someone had to help him open the door? Is it because for some reason in one of the videos, my client walks up to the car and he looks down and there's some type of cat litter, wet big cat litter box underneath his car, which he never saw before? Was that set up by the videographer or an agent of the videographer to have my client bend down, something he can't do anymore without pain? This is why you always have to tell the client, which we always do, even from when we sign the case up, beware of the video surveillance, because you know what I always say? The video surveillance is the third lawyer at the table. Shut the lights off, Your Honor. Let's show the video. Depending on what that video shows, it can be very damaging. So we always try to make sure the client knows you're looking to get justice from an insurance company or big company. They're willing to spend on a retired police officer to get you on a surveillance video doing things you said you can't do.
And the same thing with social media, right? You don't want to be on TikTok doing crazy dances or on Facebook or whatever, Instagram. You want to be, in line with your testimony. But here, they didn't really have much, and I thought that was actually kind of, intrusive, like really following him around, sitting outside his house. They had him talking at one point with somebody, and they had him at one point walking, and he was always, using the cane. Sometimes he would have the cane, but he wouldn't use it as much, and that was their argument, because I spoke to the lawyer, the main lawyer from the defendant who was negotiating the case, and he said, oh yeah, he's using the cane, but sometimes he doesn't use it, so then, we could argue that it's just like a prop, but they didn't really have much on him. Like I said, and that was funny that I think it was them. I mean, who else would put a huge bag of cat litter under someone's car? They were probably thinking he's gonna have to bend down and move it in order to get out of the parking space. But that's just like they're getting really sneaky there. But he was well prepped. Rick prepped him so well that he's just like, all right, so I'm just gonna leave this cat litter here, bye-bye.
To address the lumbar fusion, it also actually brings to thought and to my mind process, what are you as the viewer thinking, how does this equate to money? Money damages, which is all our client is entitled to in the long run. When we speak to jurors, we always say, our client's not looking for a lottery ticket or a new mortgage. He just wants fair and reasonable compensation under the law. So now here he is in his late 40s, never had a problem with his low back. Suddenly, in the middle of COVID, where he had to start seeing doctors again, which is why the gap we would have worked with fine, because we would have brought to the jury's attention. Many people don't want to keep going to a doctor for 1 year and 2 years and 3 years with all the medical treatment that Arkady was speaking about. But sometimes you don't have a choice. Now our client winds up in front of an orthopedic spine surgeon. Surgeon, after looking at tests and looking at records, determines this pain is not going to go away. This jelly donut that Arkady just brought up, it's popped forever on 2 different levels in your low back. There's only one way to get this cured. You're going to have what's called a lumbar discectomy with fusion. What that means for you and me is they're going to turn him around. His face is going to be facing the floor. It's going to be under general anesthesia. The risks involved, just to tell you, it goes from paralysis to death every time you get on an operating table, much less this type of surgery. Your back is opened up, they make flaps. First they draw an X, then they open it up, and now the surgeon is looking at your low back. Take out all the disc material and the ooze that came out, and then to keep them together, kind of like a carpenter, they actually nail in 2 metal boxes and put 2 rods in the lower back and close them up. and pray to all aspects that he will have some type of healing. Nevertheless, ladies and gentlemen, I'll tell you, when he would have walked into court and when he walked into our office every single time, the man is with a cane for the rest of his life. So how does that equate to money damages? $195,000 was offered. So Mr. Frekhtman decided, let's get an economist on this. Let's get him back to the doctor and let the doctor, the surgeon, tell us what's he going to require for the rest of his life. By the way, he also had a very serious cervical neck spine injury, which would have required, according to that same surgeon, fusion in the neck, where they would have had to approach him in the front and put the same metal devices. The treatment he required for the rest of his life, by a report that we received from his surgeon, that report broke down physical therapy, future pain management, future surgery, and there are numbers, monetary numbers attached to what our client would have had to spend for the rest of his life. We gave those numbers to an economist, and now we're talking money, hard numbers. The way we ask a jury to award money is past pain and suffering, and the loss of enjoyment of life. You can't quantify it. You can't put numbers on it. How do you pay someone back for what they've lost? Then future pain and suffering from the date the verdict is being taken by the jury for the rest of his life. Again, you can't put a number on it. However, you can put a number on the future medical costs. So physical therapy, which may cost $150 a session today, since he, by actuary tables, is supposed to live till he's about 81 or 82, that $150 session is now $475. We wound up getting a future number cost, because we hired an economist, $2.6 million in hard numbers alone. So we were prepared to ask a jury for several $1 million for past pain and suffering, and for the rest of his life, future pain and suffering justice in the amount of 17 to 20 million. The defendants knew that, and that pushed the case forward towards our settlement.
That's definitely a good idea, because you have your treating doctor, and the treating doctor knows what the costs are in that city where the doctor practices and where the client lives. So you could talk about future prescriptions, future physical therapy, future fusion, right? Because if you have a fusion, let's say at L4, L5, there's something known as adjacent segment disease. So you're medically going to need, there's a medical probability that you will need a fusion at the adjacent level. So that's 2 more surgeries. Each surgery is like right now $150,000, but if he needs it in 20 years, it might be 200 something thousand. So just that could be $500,000 having the 2 surgeries. But also, like we said, physical therapy, prescriptions, different types of medical visits, chiropractic, so it all really adds up. With the economist and the doctor together, we had $2.6 million just in these future medical expenses. But then the biggest part of the case is always going to be the pain and suffering, as well as the loss of enjoyment of life. And we get that just from knowing what the injury is, knowing that it's a fusion surgery where he had this cage put into his back with rods. He had rods, external, rods in the back, like vertical rods. He had to do it because it was a posterior approach. So it was a very major surgery, and we had illustrations from a doctor illustrator who drew everything, and we had medical illustrations showing the type of surgery. And it really had an effect on his life. For example, he lived with his wife and 2 kids, and at the time of trial, his kids were 17 and 16, so they were going to high school. One of them was already about to go to college, the other one was in high school, and they felt like they lost their teenage years because he was, the fact that he was so hurt, they had to do a lot of things like the food shopping, carrying the bags up the stairs, cleaning the house, more chores, and they lost their teenage years. So that's an effect on his kids, but then it's also an effect on him because he feels like, well, I'm the father, I want to be like the man of the house, I want to, enjoy my time with my kids, but I can't, and now I feel like I'm a burden to these kids instead of being a father to them, and that's very overwhelming. And I also interviewed his brother. He had a brother who said, like, we used to play basketball, we used to play handball, we used to go to the gym, we used to work out together. In fact, we used to, always see who could bench press more, like brothers, they want to be competitive. And now it's the exact opposite. Like, he doesn't do anything. He doesn't even hang out anymore. He just stays home. He's not able to do stuff. The whole family would go, when it was somebody's birthday, they would go to, let's say, a park, and they would barbecue. They would go to like the 7 Lakes near Bear Mountain to get together with the family and nature, and everybody would go to the pool, and the plaintiff, our client, would just be left behind to sit there, and he wouldn't be able to go to the pool. He wouldn't be able to engage in activities. So he felt almost like less than. He was a kind of a forced isolation. He doesn't want to be alone, but he has to be, because he's not able to swim. He's not able to engage in these activities. So it's like a forced loneliness, and it's a forced loss of connection, which are things that are hard to put a number on. But some people might say, hey, this is priceless. This is worth everything, because if I can't be with my family, if I can't enjoy myself, then I lose my ability to be happy, which is everything. So it was very, very powerful. So we got into a lot of this by getting to know him, by really doing a deep dive.
And in this case, believe it or not, we were not going to make a claim for loss of employment, loss of earnings. However, we were going to claim, because he could not work anymore in the production business, he actually had to make application to the federal government and go on assistance. So when you look at the jury and you're trying to tell them, award money that's fair and just, we were going to bring it to their attention that fair and just is that this man at least be able to pay his bills, pay for his medical treatment in the future, be able to live a life without basically just making it and maybe not making it and having some hard times. All as a result of an accident. Let's see, go over a manhole, up in the air, down. Within 3 seconds, our client's life was changed forever due to the negligence of a big utility company. There has to be an answer, and that's why we take these type of cases.
Yeah, I think like if the case would have gone to trial, the total amount would have been high, because you have 2.6 in future medical expenses. So those are the hard numbers. That's already a significant amount. For the past, you're talking about from 2018 to 2024, that's 6 years having something like this. This is a serious, life-changing, major back surgery where he's not able to live pain-free, not able to enjoy himself. So you figure a case like that would probably be at least like from 3 to 5 million in the past. And then in the future, you're talking about a long time. I think it was like 27 years, because he was in his 50s. And like Rick said, the pattern jury instructions say you're going to live to be like 82 or something like that. So talking about like close to 30 years future. I think it was 27 when I looked at the pattern jury instructions. So that would be probably at least something like 7 to 10 million future. So altogether, it could be much more. But practically, if you do get a verdict like that, right? Let's say you get a verdict of 10 million, the defendant will say, oh, that's excessive, and they're going to file an appeal, and the appeal will take 3 years, and then the appellate division may say, you know what, that is too much, do a whole another trial, or take a smaller number like 1.5 or 2 million. So once we had, the 2 million already, 2.2, and the client really wanted it, I felt like we could have pushed for a little more. We could have fought with them a little more to get it up there to like the 4s or 5s. We had a strong chance, but the clients didn't like that, where they say, if you don't take the offer now, we're going to take it off the table. I don't know, like, what do you think, Rick? Do you think they actually do that? They actually take the offer off the table, or is that more like a scare tactic that they use to scare unsuspecting clients?
Well, here's the difference. The utility company, they're owned by shareholders. So it really is like the plaintiff on an award or on a settlement. It really is money out of the shareholder's pocket. So many times they're doing a balance. How much are we going to pay the lawyers that represent us, the shareholders, the company? How much are we paying them? And what's the risk of our exposure to have to pay much more than what we've expended so far and what we're offering? So Arkady's point is well taken. If you look at the past numbers in 3 to 5 mil, future possibly 10, what we did then is we put it all into the soup for our client, who is our main interest. So we look at the client who's living in the Bronx in a 2-room small apartment, which we visited. I mean, it was so small, it was hot. They need a new life too. They need a new hope, a new dream. To tell these people at 2.2 million, let's take a shot And if they do take it off the table, we've got to go all the way. And possibly, even if we get a large number, it goes up on appeal and you're waiting another 3 years. We thought the right thing to do for this case, since we brought it, as Mr. Frekhtman said earlier, 10x, 10 times. We went from 195,000 to 2.2 million. The client was 100% satisfied, so we thought we did the right thing in this case and said, you know what, we'll settle it. We did well, they're happy, so we were happy. So viewers, it's been a pleasure up to this point to present the trial and the aspects of the trial on liability and damages, but I want to give it over to Arkady so you can see what we were prepared to argue at the time of summation.
Yeah, so we basically went over everything, and at the time of summation, depending on how the trial went, what we would have done is we would have probably told the jury what is civil justice in this case. So something like, when you match up the law and the evidence, a verdict of $15 million will be justified, and explain why, right? Like we talked about, 3 to 5 million for the past, 7 to 10 million for the future, plus 2.6 million in these economic damages. And the reason we were able to do all that is because we had an economist, we had a spinal surgeon that we went to his office on a Saturday and we spent hours preparing with him. We had everything lined up, right? The medical timelines, all the medical records, everything subpoenaed to court, all the trial preparation. We had the human story by going to his house, by interviewing not only him, but also his circle of friends and community witnesses. And I felt like the story was alive within us, so we could have always argued and argued passionately because we really cared about the person. He was a really nice guy, humble, soft-spoken, but you could see his life was changed. And that's the main thing, right? When you have a case of merit, when you see a real case, you want to help them, and it's almost like it's not work. It's just a passion because you love doing this and you want to do everything to help them and get them full justice. So this was one of those cases. So we were just happy that we were able to win it and able to get a successful settlement. So thank you, everyone. Please like and subscribe to our channel. Let us know what questions you have. If you need a consultation, just text me. It's 347-566-9595. And let me know your name, the facts, and your injury information, and your city. And I'm happy to schedule a free consultation. And like we said, we are here to help serious injury victims and families. And we are here for you. Let us know what questions you have, and all the best. Okay, bye-bye.
Bye.